All right. Will your client waive the formal reading of the motion?
He will, Your Honor.
I didn't already have that, sorry. This is cause number 25, DCCR 0895. And Mr. Douglas, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation November 18th of 2025 for the offense of obstruction or retaliation, a third-degree felony. And that was a 3-year deferred probation. Is that correct? And this motion alleges that you violated your probation in count 1 only by failing to act in a courteous and professional manner, by incurring 3 new incident reports while housed at the Jefferson County Jail, including a physical altercation with another inmate on November 29th, 2025, which was the same date of your last hearing. And so, is that true or not true?
True.
Did you enter your plea of true to count 1 freely and voluntarily?
Yes, ma'am.
And because it's actually true?
Yes.
And I guess once you did that, you decided, screw it, I'm going to do whatever I want because I already know I'm going to get in trouble, because you've been acting like an absolute fool in our jail. I'm not sure 4 years is enough. I need to think about this for a minute. I mean, is it really that hard to follow the rules?
No.
You didn't want to get out? You did? You got a problem with showing yourself while masturbating to the female officers out there, don't you? You don't?
Ain't got no problem.
You don't have a problem? You just like to do it and you think that's cool to do that in front of them? Even though you know you're going to get written up and go to prison for that? Was that worth it?
No.
Have a seat in the jury box. I'm not sure that I'm going to accept this agreement. All right, so just for the record, and I've gone back to review the pre-sentence report just to remind myself of what was in that and kind of what got us where we are now. And Mr. Douglas, I hate this because I really, really, really wanted you to succeed. I really did. I wanted you to be able to go to ISF, but I can't not stick to my word. I told probation when you were here. I told you when you were here. No more incident reports before ISF or you're not even going to make it. And it has been 1, 2, 3, 4, 6, 7 dozens at least. The sentence date was supposed to be, the sentence date was November 18th. So since November 18th, you've been caught with looks like kind of a makeshift tattoo needle. We've got 1, 2, 3, 4 or 5 at least times when you have been exposing yourself while masturbating to the officers, spraying other inmates with disinfectant spray, horse playing, smoking. I mean, it's just.
Judge, I certainly understand your thoughts about it not being enough time, especially with the incident reports you're having a problem with on all these people in the jail.
No, I think I'm going to go along with what you guys have agreed to. I just wanted some time to look at it. I'm just reminding myself of all. I mean, the fact that you got this in the first place, because we went through. I have it all marked off on this PSI. Your juvenile history and the opportunity you were given now that you're an adult to change your life and just follow simple rules. So I am going to, let's see. So I have documents here on this tablet that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
Do you understand, if I go along with this agreement, that you're waiving any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Douglas is not competent?
No, Your Honor.
All right, Mr. Douglas, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true. Find sufficient evidence at this time to find you guilty. Okay, something wrong. Find you guilty of obstruction or retaliation, a third-degree felony, sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. And so today, just Mr. Douglas, just because you got time today does not mean that you still can't do better and change your life. Better you act in prison, the sooner you're going to make parole. The sooner you do that, you can get out, hopefully follow the rules and have the best life you can. You get in TDC and act like you've been acting in our jail, you're going to end up doing the whole 4 years. But you're eligible for parole in less than 2. In about 1.5 years, you're eligible for parole. And that's going to be 100% up to you. And I can assure you, you're not going to get it if you keep acting like this. All right? You can go back with the bailiff. Are there any additions or corrections?
Nothing changed.
Nothing state, Your Honor.
Well, Judge, there is one issue that was brought to my attention this morning by Mr. Alonzo in regards to his criminal history. I think there's a notation there from the federal issue, and according to the report we have, that he pled guilty and was sentenced time served. According to Mr. Alonzo, he was granted asylum during that time, and wasn't actually sentenced in that matter.
Is there currently an ICE hold?
I don't know that concern me.
Can you check, please? Is there, but Mr. Lazo is not here legally, correct?
No.
Okay.
Yes. Okay. See, where's the young and us? We're not holding it. Okay. So you want some volunteers.
All right, Mr. Lewis, you may proceed with argument.
Well, Judge, Mr. Alonzo, he's been pretty straightforward from the beginning of this case of his involvement. He's taken full responsibility, trying to be as cooperative as possible in this matter so the proper parties and everyone can be made whole, especially dealing with the victims and what they lost out on, even to the point where he didn't know the victim would be here, but he did prepare a letter of apology that at some point he would hope been able to read or let them know of. He does understand he does have other holds from different counties that has to be addressed as well. So at this time, he's really just asking the court for as much leniency or mercy as possible as far as going forward to resolve this matter.
Thank you, Mr. Nichols.
Your Honor, I took into account his cooperation and willingness to accept responsibility when I capped it at 15. This is a pretty horrific robbery where they targeted this woman who's sitting right over here. He knocked her to the ground while holding a gun. They stole $80,000 in cash from her business. They've been targeting this woman. They've been following her and planning this for months, Judge. And I know another individual was involved. That case is pending. Mr. Lazo did essentially debrief as to how they got there and what they were doing. And that was taken into consideration when the cap offer was made. But the facts of this case, Judge, I think 15 is more than appropriate. She was terrorized. She was brutalized. She was injured. And had to go through this. She lost items that can't be replaced. Some belonging to her late husband they stole from her. They stole her passport along with this huge amount of cash that was from her business. It was obvious they had targeted and sought her out and followed her. And that this was not just some random occurrence, that it wasn't just a time of opportunity. They came in from Houston to do this, and they've been planning it for some time, Judge. So I ask the court to assess the full 15.
Anything else? Mr. Lazo, I appreciate your attorney's arguments, asking me for leniency, but any leniency that you I don't even know if deserve is the right word, but are getting, was because of the agreement that your attorney reached with the district attorney for that cap of 15 years. What you two did, to Ms. Ordaz is absolutely something, it's out of a movie, scary, for a person who is just living their life, trying to run a business. And in my opinion, 15 is really probably not enough, but I understand, and I think she probably feels the same way. I appreciate, and I'm sure everybody, including her, appreciates you taking responsibility so that there wasn't a drawn-out trial, so that everybody involved is going to also have their day in court. And so based on all of that, at this time, I'm going to find that you previously entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated robbery, sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon. I'm going to hand you the trial court certification. This shows that this was an agreement I followed, and so you have given up any right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. It's in Spanish, and you need to read it carefully. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. And if you guys will have a seat at council table, we will go off the record for a victim impact statement.